Hi, and welcome to all of our followers. My name is Stephanie Mata. I'm an associate attorney here at the law offices of Beltran-Brito-Casimir. Today, we're going to be reviewing all the questions we've received from you. Again, you can always submit questions to us through our YouTube channel, Beltran-Brito-Casimir, on Instagram at Beltran-Brito-LLP. We try to do this as often as possible. So if we have a round of questions, we're going to go ahead and do it on a weekly basis and answer your questions. So please submit new questions to us, and we'll go ahead and answer those and get you a response as quickly as possible. So let's begin. First question. I have a question. Why has USCIS sent me a working authorization and a social security number, and then in 2 weeks they sent me a schedule for your green card interview? Is this normal? That's normal, and that's fantastic. Yes, a lot of the times when you're applying for your I-45, your adjustment of status for your green card, you're simultaneously applying for a work authorization, I-765. A lot of the times, just based on processing times, work authorizations are taking a long time. We're talking, I think the last time just last week, I had a client that was waiting 6 months for their employment authorization. But if you received your employment authorization card, your EAD, and then you received your interview for your green card 2 weeks later, that's fantastic. That means they're making progress and moving forward on your I-45 application. Your green card is moving forward. Hopefully you can get your green card very, very soon, and you won't ever need to renew your EAD. It's very good news. You should not be concerned. In fact, it's fantastic because you should hopefully get a green card in your hands very soon. Next question. Can I have two I-45 applications pending? So I-45 application is an application for adjustment of status. You can, in theory, present two petitions. Let's say you have one petition that's based on family, one petition that's based on an employment. You can, in theory, present them. However, immigration will force you to withdraw one petition before they adjudicate the next one. So you'll usually receive a notice in the mail that essentially says, we have two I-45 applications pending for you. Please notify which one you would like to proceed with and withdraw the other one. They will require you to do so. You can present them, but ultimately both won't be adjudicated. Okay, next one. Can I apply for an E3 and an L2 at the same time? I mean, in theory, you can, but it's preferable. An E3 is a visa for Australian nationals, right? An L2 is going to be the spouse of an L1. You can apply in theory for both. However, it's going to be much more preferable to apply for an L2, the spouse of an L1 visa holder. Why? Because an L2 will be eligible to receive an employment authorization, which allows you to work in any field in the United States of America. It's going to give you a lot more liberty. Your E3 visa is going to be tied to a specific job, a specific company, which will only require you to work for that company. If you have an L2 visa that comes with an EAD, you could work in whatever in the United States. It's much more preferable to take that route. Next question. I was F1, then OPT, but my OPT has ended on May 19th. Now I'm under I-45 pending. Am I required to purchase health insurance? Okay, so there has been a lot of talk. We're currently in October 2019. We have a lot of talk regarding the health insurance. Basically, there was a presidential proclamation that essentially says anyone who's applying for adjustment of status or permanent residency in the U.S. has to show that either they have health insurance, can obtain health insurance within 30 days of your interview, usually, they haven't clarified much, or can potentially pay for a medical emergency, right? So there hasn't been a lot of information on that. We're talking, this came out last week or a week and a half ago, and so there's not really any explanation as to how this is going to be documented, how this is going to be implemented. For now, the recommendation is yes, you're going to need to show that you do have health insurance because that's what's currently the state of affairs. However, a lot of these things, such as the public charge questions, they're currently going through the courts. There have been injunctions where they have stopped, for instance, use of form. The new I-45 form that asked about the public charge information, and I think a couple of questions about the health insurance questions, they have been frozen. So immigration is not allowed to enforce or not allowed to request this new version of the form until this forms go through the courts and the courts approve those forms. So right now we're in limbo a little bit. We don't have too much information regarding the health insurance mandate, or essentially whether there's a requirement for applicants for permanent residency need to have health insurance. But I do highly recommend, if you have your interview coming up soon, either enrolling in health insurance or being able to show financially with bank statements that you would be able to buy health insurance, or you would be able to pay for a medical emergency if there was one. One important note, it looks like subsidized health insurance under the marketplace will not be good enough for these purposes, right? This is a wait and see sort of thing. As your interview approaches, I would recommend talking to an attorney, an immigration attorney, to see what's the current state of affairs and what do I need to do in preparation of my interview. Next question. Who is responsible for paying the labor certification? Is it the employee or the employer? So the labor certification process, known as the PERM process, is an individual or a company wherein they are requesting for an individual to come to the United States to work with them, right? So they have done a national search. It ends up being that the foreign alien is truly the best candidate for their work, and that's a labor certification application on it very generally. The employer must pay for all fees related to the PERM application, all fees related to immigration, all fees related to Department of Labor, advertising, everything, because they are looking for the candidates. So the employer must pay all fees. Once you're at I-45 stage, which is adjustment of status, that's when you can pay your own fees because you are requesting a green card based on the already approved PERM application. That's the only point in time where the employee himself can pay for the I-45 fees with immigration. Other than that, employer has to pay for everything. Next, can I apply for an E-2 visa while in the United States? What constitutes an investment in order to be approved? An E-2 visa is a temporary visa based on an investment here in the United States. The important part is all of the money has to be committed before entering the United States or before applying for the visa. So essentially you're making an investment, you've purchased either an existing business or you've purchased everything to make a new business, including the materials, the supplies, the technology, the location, everything. You've committed those funds. That's the most important purpose for the most important fact for E-2 visas. An E-2 visa can be done as a change of status and it can be done consular. It could be done both. I usually prefer consular because if you do an E-2 change of status, so you're currently in the US, let's say as a tourist, then you do your investment and you apply for your E-2 visa and they change your status from tourist to E-2. That's perfectly fine. But if you travel and you have to go get that visa actually stamped in your passport in order to re-enter, you have to go to a consulate and represent this entire process. You have to represent your entire petition for your E-2 visa. So you're getting adjudicated twice. For that, get adjudicated once at the consulate. You don't have to go through this process again. But my recommendation usually is, especially for a person who frequently travels, do this through the consulate. That way you really only have to do it one time. Again, if you're doing change of status, the second you leave, you have to go to a US consulate, present all the information related to the investment in order to get that visa stamped in your passport. Next question. I'm currently looking at moving my family to the United States. I have no idea where to start or which application I need to apply for. You've come to the right place. I highly recommend meeting with one of our immigration attorneys. Here at the offices, we have experience in all types of petitions. As you can see from our videos, there are 1,000,001 types of petitions. You have family, you have employment, you have temporary, you have permanent. There are a lot of types and it depends really on what your family wants. Do you want to come permanently? Do you want to come for a time? Do you want to see how it goes and then maybe go permanent? My recommendation is meet with one of us, meet with our immigration attorneys. We're going to go ahead and walk you through every single option. I like to give multiple options for my clients, and we can decide what's the best course of action. I usually like to establish a short-term course of action and a long-term course of action, but depending on you and your family's needs and what they want to do. So my recommendation is contact us. You can contact us on our social media channels at Beltran Brito LLP, Beltran Brito Casimir on YouTube. You can also write to us at info@beltranbrito.com. Any questions you may have, let's meet for our consultation. Make sure your resume, your CV is up to date so that we can go ahead and evaluate if employment-based petitions are an option for you as well. Next question. Does USCIS know anything prior to your application? That's an interesting one. I mean, they have, let's say you've submitted an I-129 petition. In your I-129 petition, they don't know who you are. You're submitting, let's say you're an actor. You're submitting an I-129 petition as an actor. They're evaluating everything that you've submitted. However, that doesn't mean that they can't do extraneous research, okay? So before that petition is in hand, they probably don't know who you are. But once they receive that petition, they are certainly open and able, and they do it because they state that they do so, able to go online and research you. They can go online, they can look at your IMDb, they can look at your social media. They have the ability to research. This is not a closed world. This is an open world. They're allowed to use all resources available to them in order to investigate you and who you are. So basically make sure that everything you're presenting is readily available online and readily available. And they're gonna see and they're gonna be able to research you, and it's important to know that everything that you're putting online as your online presence is accessible to the public. Next question, final question actually. I-45 interview. If my sponsor loses a job but the foreign alien has a job, I'm getting nervous because my husband, an American citizen who is my sponsor, is about to lose his job. I'm working a better paying job on an H-1B and could prove that I continue this job after a green card is issued. So Essentially, this is a situation where this is a marriage-based petition, U.S. citizen petitioning for his foreign alien spouse. What happens here is the U.S. citizen provided an affidavit of support, saying basically that I can provide financially for the foreign alien if need be. The foreign alien's job is irrelevant. There has to be someone who could financially support the foreign alien in the United States. If the U.S. citizen, right here we put about to lose his job. So right now we're fine. But if the U.S. citizen does lose his job, I do recommend getting what's known as a joint sponsor before your interview. Basically, this is another individual, another U.S. citizen who could state that on an affidavit of support, they can provide financially for the foreign alien. It doesn't matter that you have a great job on the H-1B. You need to be able to have someone who could financially support you that's a U.S. citizen here in the United States. So if your spouse loses the job before the interview, then I would recommend getting a second affidavit of support, bringing it with you to the interview. Thank you so much for all of your questions. Please submit more, and we're happy to do this on a regular basis. You can contact us at Beltran Brito LLP on Instagram or Beltran Brito Casimir on YouTube. Thank you so much.